You're listening to an African Elements top news story for June 16, 2025. Please visit our website at africanelements.org for more daily news. North Carolina Redistricting, Allegations of Racism, by Darius Spearman, African Elements. North Carolina's congressional and legislative election maps presently face a critical trial before a three-judge federal court panel. This legal challenge centers on serious allegations. Additionally, the plaintiffs claim that racial discrimination significantly influenced the creation of these maps. The case has drawn national attention, placing North Carolina prominently in the ongoing debate over fair redistricting across the United States. Furthermore, national watchdogs and activists view the state as a key battleground, accusing Republican lawmakers of deliberately drawing maps that diminish the voting power of minority communities. Across the country, multiple lawsuits are targeting maps drawn after the 2020 census. These legal actions frequently highlight accusations of both racial and partisan bias. Critics, including numerous voter advocacy groups, allege that North Carolina's Republican-led legislature intentionally divided Black and brown communities. Therefore, this action sought to reduce their collective political influence. The lawsuit explicitly claims that these maps undermine the Voting Rights Act of 1965. This legislation aims to protect the power of marginalized groups. It attempts to ensure that communities of color can effectively elect their preferred representatives. The Voting Rights Act of 1965, known as the VRA, stands as a pivotal federal law. It was designed to prevent racial discrimination in voting. Specifically, it prohibits vote dilution. The VRA ensures that minority groups have meaningful opportunities to participate in the political process. This includes the ability to elect their preferred representatives. The VRA specifically safeguards minority voters from maps that diminish their voting power, making certain that their votes hold equal weight in electoral processes. Section 2 of the VRA is particularly important. This provision makes it illegal for states to engage in practices that deny or abridge the right to vote because of a person's race or color. Consequently, when redistricting efforts lead to minority voters having fewer opportunities than other members of the electorate to participate in the political process, the VRA offers legal recourse. It provides a pathway to challenge such maps and rectify injustices. Packing and cracking represent key gerrymandering tactics. These methods are commonly used to manipulate electoral outcomes. Packing concentrates a specific group's voters into as few districts as possible. This approach minimizes their influence across the wider electoral landscape. Conversely, cracking dilutes a group's power by splitting them across many districts. This prevents them from forming a majority in any single district. Both tactics serve to diminish a group's ability to elect representatives of their choice. They are frequently cited in lawsuits challenging redistricting maps. These strategies directly impact racial gerrymandering claims. They are often used to reduce the collective political voice of Black, Latinx, Asian, and Indigenous communities. Therefore, such actions are viewed as schemes that unjustly come at their expense. These practices make it significantly harder for Black and brown communities to achieve proportional representation in legislative bodies. This leads to profound consequences for their advocacy and political power. Republican-led legislatures in the South have faced historical scrutiny. These legislatures are associated with efforts to redraw district maps in ways that reduce minority political power. They often use tactics like packing and cracking to dilute minority vote strength. Indeed, Southern states have encountered multiple legal challenges concerning redistricting actions that sought to diminish the political power of Black and brown communities. These legislatures have routinely faced accusations. Such accusations claim they manipulate district lines to benefit white conservative candidates. Moreover, they disadvantage minority voters. These efforts frequently lead to litigation under the Voting Rights Act and amendments to the Constitution. The term brown communities is often used colloquially to refer to Latinx or Hispanic groups. However, in redistricting discourse, it can also include Indigenous and other communities of color, though this is not always specified or universally understood. In many legal and journalistic contexts, Black and brown communities serves as shorthand for Black, Latinx, and sometimes Indigenous and other communities of color. While current trial coverage focuses on legal arguments, prior North Carolina redistricting battles have provided insights. These earlier cases have demonstrated patterns of minority vote dilution. National trackers of redistricting litigation routinely cite multiple instances where statistical analysis has revealed significant disparities in representation for Black and brown voters in North Carolina. These historical precedents underscore the ongoing challenges faced by these communities in securing equitable political representation. The Voting Rights Act is a federal law. Interpretations and rulings in one state can set precedents. These precedents influence redistricting challenges across the entire country. The pursuit of justice in these cases extends beyond state borders. Expert analysis is noted as a key component in proving racial gerrymandering. The outcome of North Carolina's current trial will therefore be keenly observed, potentially shaping the future of voting rights for Black and brown communities nationwide. Copyright African Elements.